Good day, everyone, and welcome to Media Laws and Ethics. Last time we talked about the excesses of media, the constitutional provisions affecting the media, and now we will talk about ethics, the question of ethics. Okay? Envelopmental journalism is now common to those within the profession and outside. This refers to a sum of money usually placed in an envelope given by some unscrupulous officials to some equally unscrupulous newspapermen. The purpose of this gift is either to have a story with a slant in his favor, to be written and published, or to silence the reporter or keep him from writing about certain things that he knew. Some years back, Beth Pango, a congressional reporter for the Inquirer, wrote an expose about a payola. Pango said that during the hearing of a House committee looking into alleged participation of former Trade and Industry Secretary Jose Concepcion in the Luzon petrochemical deal, some of his aides allegedly passed 1,000 pesos in crisp 100 peso bill to newsmen covering the hearing. The expose created a stir in media circles and prompted the National Press Club to conduct an investigation. After a series of closed door hearings, nothing came out of the case. NPC officials explained that some of the witnesses refused to cooperate so that the probe had to be called off. If the same is true, those newsmen who took the money have violated the NPC promulgated Code of Ethics for Filipino journalists. The following, ladies and gentlemen, is the full text of the code. I shall scrupulously report and interpret the news, taking care not to suppress essential facts, nor to distort the truth by omission or improper emphasis. I recognize the duty to air the other side and the duty to correct substantive errors promptly. I shall not violate confidential information and material given me in the exercise of my calling. I shall resort only to fair and honest methods in my effort to obtain news, photographs, and documents, and shall properly identify myself as a representative of the press when obtaining any personal interview intended for publication. I shall refrain from writing reports which shall adversely affect a private reputation unless the public interest justifies it. At the same time, I shall fight vigorously for public access to information as provided for in the Constitution. I shall not let personal motives or interest influence me in the performance of my duties, nor shall I accept any offer, any present, gift, or other consideration of a nature which may cast doubt on my professional integrity. I shall not commit any act of plagiarism. I shall not in any manner ridicule, cast aspersions on, or degrade any person by reason of sex, creed, religious belief, political conviction, cultural, and ethnic origin. I shall presume persons accused of crime of being innocent until proven otherwise. I shall exercise caution in publishing names of minors and women involved in criminal cases so that they may not unjustly lose their standing in society. I shall not take unfair advantage of a fellow journalist. I shall accept only some tasks as are compatible with the integrity and dignity of my profession, invoking the conscience clause when duties imposed on me conflict with the voice of my conscience. I shall comport myself in public or while performing my duties as journalist in such manner as to maintain the dignity of my profession. When in doubt, decency should be my watchword. When you are in your practice, ladies and gentlemen, we should be guided by those principles enunciated in the Code of Ethics for Filipino journalists. We should not lose sight of the primary goal of journalists, and that is to be watchdog of the society. We are considered to be the fourth estate, wherein we serve as the fiscalizer with the other three branches of the government: the executive, the legislative, and the judiciary. So we have to be fair, we have to be objective, we should not be corrupted. Alright? Now, in spite of the constitutional guarantees, freedom of the press in a democratic society like what we have in the Philippines has its own limits. There's no absolute freedom. In fact, the same Bill of Rights, which guarantees our freedom of the press, provides that the privacy of communication and correspondence shall be inviolable except upon lawful order of the court or when public safety or order requires otherwise as prescribed by law. This provision presupposes that even if you enjoy your freedom of the press, you cannot pry into the private communications of another. The state has to protect other people's rights. Okay? In the same way, even if you have freedom of speech, you cannot just freely say, fire, or there's a bomb here in a crowd, or in a movie house, or in an airport, because the state protects other people's well-being. Your shout could result in a panic inside that movie house or inside that airport, as the case may be. Now, there are at least six major limitations to press freedom, namely libel, anti-obscenity law, invasion of privacy, law on national security, contempt of court, and the copyright law. Let's start off with libel. Libel is defined as a public and malicious imputation of a crime, of a vice or defect, real or imaginary, or any act, omission, condition, status, or circumstance tending to cause dishonor, discredit, or contempt to a natural or juridical person, or to blacken the memory of one who is dead. The basis of this is the revised penal code. And if you remember, in the past, we have discussed that there is also what we call online libel. We will extensively discuss libel later on in our discussion, okay? We shall proceed now to the second limitation, which is the anti-obscenity law. These are offenses against decency and good customs, and they are also penalized in the revised penal code. These would include immoral doctrines, obscene publications or exhibitions and indecent shows, publications or materials prohibited under this law are those that tend to glorify criminals or condone them, those that serve no other purpose but satisfy the market for violence, lust, or pornography, those that offend a race or religion, abet traffic in and use of prohibited drugs, encourage acts contrary to law, public order, morals, good customs, established policies, lawful orders, decrees, and edicts. Remember, kaning anti-obscenity laws, ladies and gentlemen, is something offensive to chastity, decency, and delicacy. One example, ane, wherein a publication served no other purpose but to satisfy the market for lust or pornography is, say, when there's a picture of a man and a woman having a carnal knowledge. When you say having a carnal knowledge, having sex, okay? And it will be published in a newspaper, and there will be a caption and there will be a story out of that particular picture. That is a limitation to our press freedom because this serves no other purpose but for lust, no, to satisfy the market for lust, and that is not allowed under the revised penal code. Okay? Now on to the right of privacy. We also extensively discussed the right to privacy, so I will just leave it at that. And now on to the law on national security. Under the revised penal code, any person who is found to incite people to sedition or rebellion or commits acts that will endanger security and safety of the state shall be penalized. When you say sedition, no, these are acts that are political and social. May kag-rebellion, crime of the masses ni siya. It happens when the masses form into a vast movement for the purpose of withdrawing from the obedience of the government, laws, territory, deprivation of the government, the executive, the legislative to exercise their prerogative or function. And this is basically a political act, okay? Some publications that are considered seditious in the past are the following: tend to incite others to sedition, constitutes scurrilous libels against the government or against any of the constituted authorities, tend to disturb or obstruct any lawful officer executing the function of his office, tend to instigate others to cabal and meet together for unlawful purposes, suggest or incite rebellious conspiracies or riots. If you remember, during the height of the ECQ, a lot of Cebuano individuals were actually arrested under the premise that they were actually inciting to sedition for posting articles or writing columns that would tend to incite others to disobey the lawful authority or to disobey the orders of the government. Next is contempt of court. Judicial contempt may arise whether a case is pending in court or not. When a case is pending, the orderly administration of justice is to be protected. Any improper conduct that tends to directly or indirectly impede, obstruct, or degrade the administration of justice is contempt of court. A publication is liable for contempt if it clearly shows tendency to impede the administration of justice, if it is directed toward the court and is not a report of fair comment upon an action before the court, if it takes place while the case is pending or has not been decided yet. And lastly is the copyright law. The copyright law is designed to protect intellectual property. Applications for copyright can be filed with the National Library, and intellectual works that may be copyrighted include books, periodicals, lectures, dramatic compositions, maps, etc., etc. If a work is in violation of the copyright law or if a work is being infringed, the author of a particular work or the original author of the work may file for an infringement proceedings and in return claim for damages sa tao nga ning violate sa iyahang intellectual property. Okay? We now go to libel. Libel, as earlier discussed, is a public and malicious imputation of a crime or a vice or defect, real or imaginary, or any act, omission, condition, status, or circumstance tending to cause the dishonor, discredit, or contempt of a natural or juridical person or to blacken the memory of one who is dead. Now, when you say public, kailangan dili ikaw rin nakabasa. Okay? When you say imputation of a crime, gipasanginlan ka nga ning komiter og crime or gidaot ka tungod kay naa kay defect or vice, whether it be real or imaginary. Later you will really learn nga naay mga naabot sa Supreme Court nga mga kaso nga abi nimo inexistent but naay din in the past na hitabo. Any act, omission, condition, status, or circumstance, basta ang iyaha bitong result is to dishonor, discredit, or contempt of a natural or juridical person. When you say natural, kita individuals, we persons here on earth, able to walk, able to see the light, or basta kitang mga tao, kanang living persons, okay? When you say juridical persons, these are persons which are considered persons by operation of law. Kaning mga corporations, partnerships, okay? They're considered to be juridical persons by fiction of law, by operation of law. Gitagaan silang personality. Okay? So, if ever ang University of the Visayas, you will defame the University of the Visayas, you can be prosecuted for libel for defaming that juridical person, and that is the University of the Visayas. Also, to blacken the memory of one who is dead. Patay na, pero imo gihapong gidaot. You can still be prosecuted for libel. Okay? Now, what are the means by which libel is committed? Libel, ladies and gentlemen, may be committed by means of writing, printing, lithography, engraving, radio, phonograph, painting, theatrical exhibition, cinematographic exhibition, or any similar means. And remember, direning sud sa any similar means ang online libel. Kanang libel committed in the internet. Alright? Now, when you say oral defamation, this is also a form of libel, though orally done, and we call this as slander. Okay? Slander, ladies and gentlemen. Now, you might ask, ngano mang i-punish man nato ang libel? The enjoyment, ladies and gentlemen, of a private reputation is as much a constitutional right as the possession of life, liberty, or property. It is one of those rights necessary to human society that underlie the whole scheme of civilization. The law recognizes the value of such reputation and imposes upon him who attacks it by slanderous words or libelous publication the liability to make full compensation for the damages done. Alright? Now, the question is, asa man na i-file ang libel? Ladies and gentlemen, the regional trial court has been specifically designated to try a libel case. It is not the municipal trial court, but it is the regional trial court. Now, unsa may venue, asa man dapita, asa man nga regional trial court. Ang general rule, ana, ladies and gentlemen, is the action may be filed in the RTC of the province or city where the libelous article is printed and first published, or where any of the offended parties actually reside at the time of the commission of the offense. Ikaduha, if the offended party is a public officer with office in Manila at the time the offense was committed, the venue is Manila or the city or province where the libelous article is printed and first published. Where an offended party is a public official with office outside of Manila, the venue is the province or the city where he held office at the time of the commission of the offense or where the libelous article is printed and published. And lastly, if the offended party is a private person, the venue is his place of residence at the time of the commission of the offense or where the libelous is printed and first published. The common feature of the foregoing rules is that whether the offended party is a public officer or private person, he always has the option to file the action in the regional trial court of the province or city where the libelous article is printed or first published. Okay? Now, you have to remember that the crime of libel prescribes in 1 year from the date the alleged libelous article was published. Example, the alleged libelous article was published today, October 15, 2020. It prescribes in October 15, 2021. So beyond October 15, 2021, the offended party can no longer institute a crime for libel against you who allegedly commits that crime of libel. Okay? So it prescribes in 1 year from the date the alleged libelous article was published. Alright? Now we move on to the essential elements of libel. There are 4 essential elements of libel, namely, the imputation must be defamatory, the imputation must be made public, the imputation must be malicious, and the person defamed must be identifiable. When can we say that the imputation is defamatory? It is defamatory, ladies and gentlemen, when the crime allegedly is committed by the offended party. The vice or defect, real or imaginary, of the offended party is being imputed upon in the libelous article. Any act, omission, condition, status of, or circumstance relating to the offended party which tend to cause the dishonor, discredit, or contempt of a natural or juridical person or to bracken the memory of one who is dead. Those are the instances wherein an imputation may be considered as defamatory. Now, what is an example of an imputation of a crime? Example, aniha, if there's an article that is published and it portrays therein that the offended party was a swindler. Let's say, si Mayor Juan de la Cruz, imong gisuwat didto nga before siya nahimong mayor, usa na siya ka swindler, mangayo na siya kwarta sa mga tao dito sa iyahang komunidad, and then he used that particular money to construct a house, to the prejudice of all these individuals. And ingon ka nga kana siyang tawhana, sawa pa siya na mayor, committed a crime of staffa. Alright? So that particular instance is an imputation of a crime, ladies and gentlemen. Simply stated, no, kung mayroon kag imputation of a crime, gipasanginlan ka nga ni committer og crime. Okay, that's an imputation of a crime. Another example here is branding somebody as having murdered his brother-in-law, enriching himself at the expense of others who trusted him, calling one a bigamist and becoming rich overnight through questionable transactions and influence peddling, winning in an election through imputation of criminal acts tending to cause dishonor, discredit, contempt of the complainant. These are just among the examples of an imputation of a crime. Or pasanginlan ni mo ron nga si Dominic na ay asawa apan nangabit. That is an imputation of a crime of concubinage. So, in this case, si Dominic can always file for libel on the basis na there was a defamatory imputation over his person. Alright? Now, on to imputation of a vice or defect, whether it be real or imaginary. Calling a barangay captain an ignoramos, a traitor, a tyrant, and a Judas is an imputation of a defect. Okay? Also, calling someone as one who grabs another's husband, a flirt, a temptress, or one who indulges in enticing others' husband. That is also an imputation of a defect, because according to the Supreme Court, it does not necessarily mean na when you entice someone's husband, you become an adulterer or adulteress, as the case may be. Okay? So, ang iingon lang Supreme Court in this case, that is just an imputation of a defect or a vice, whether it be real or imaginary. Now, on to imputation of an act and omission. So, may example ani, an article signed by the accused and published in a newspaper saying that the offended party used to borrow money without intention of paying, that he had ordered the fixing of his teeth without paying the fees for the services rendered by the dentist. It contains an imputation of an act and omission which is defamatory, ladies and gentlemen. Now, imputation of condition, status, or circumstance. Example is calling a person a bastard or a leper within the hearing of other persons is defamatory. Also, writing and publishing an article containing the words coward, vile soul, dirty sucker, savage, hog, who always look toward the ground. The word fool or crazy becomes defamatory if it is used to connote mental aberration, okay? The word also mangkukulam is undoubtedly an epithet of opprobrium. To say that complainant is a witch and sorceress is to impute to her a vice, a condition, or a status that is dishonorable and contemptible. This is the case of People versus Carmen Sario, okay? Now, you also have to remember that one of the elements of libel is that the imputation must be made public. Okay? Publication is the communication of the defamatory matter to some third person or persons. Remember guys that libel is present not only when it is widely circulated, but also when it is made known or brought to the attention or notice of another person other than its author and the offended party. Remember nga bisan pag usaraan na ang makahibaw other than you and the offended party, that is already libel. There is already a publication of that alleged libelous publication. Okay? So, you have to remember ha, dili kinahanglan nga ang tibuok klase nakahibaw, enough ra nga isa rang nakahibaw from the class apart from the offended party and the alleged person who committed libel ang nakabati or nakabasa sa certain libelous article. That already constitutes publication, ladies and gentlemen. Okay? Now, you have also to remember that the person defamed must be identifiable. In order to maintain a libel suit, it is essential that the victim be identifiable. Dapat nailhan, although it is not necessary that he be named. Dili kinahanglan guys nga panganlan, basta lang mailhan, okay, basta ma-identify nga kaniyang gisuwat mo, ganyan pasabot o, kaniyang pasaring diri siya magyud ni o. So as long as the third person can identify that the subject of that alleged libelous publication is that particular person, that already is considered to be, or that person is already considered to be identifiable. It is enough if by intrinsic reference the allusion is apparent, or if the publication contains matters of description or reference to facts and circumstance from which others reading the article may know that the plaintiff was intended, or if he is pointed out by extraneous circumstances so that persons knowing him could and did understand that he was the person referred to. Okay? So di gyud importante nga panganlan as long as ma-identify siya by some other people, ladies and gentlemen. Last element is that the imputation must be malicious. There must be an indication, ladies and gentlemen, that the offender is prompted by personal ill will or spite and speaks not in response to duty but merely to injure the reputation of the person defamed. Kailangan i-prove yun na nga there was malice in the publication. There are, however, guys, defenses to libel. Usa sa mga defenses is kaning fair comment on qualifications of candidates of public office. The mental, the moral, and the physical fitness of candidates for public office may be the object of comment and criticism. The very fact of candidacy putting these matters is issue, and the public having a right to be informed as to the qualification of those who seek election and perhaps appointment to public office. Kaning apology or retraction. Ang retraction published to correct the mistake does not really wipe out the responsibility arising from the publication of the libelous article or photograph, as the case may be. But it may mitigate the criminal responsibility. Also, kanang rectification or clarification. This will also not wipe out the responsibility arising from the publication, but it will mitigate the criminal responsibility. Also, we say that the truth is a defense for libel, but remember that the proof of truth is not enough. It is always required that the matter charged as libelous was published not only on the basis of truth but with good motives and for justifiable ends. Okay? Self-defense is also a defense. To justify one's hitting back with another libel, there must be a showing that he was libeled. Okay? Ingon siya, I should not be prosecuted for libel because it was only a self-defense. Ako siyang gilabayan og libelous nga imputation, kay iya man sad kong gilabayan og libelous imputation. In order to properly pose this or interpose this as a defense, kailangan ipakita sa niya nga there was indeed first a libelous imputation against him or her. Okay? Remember also that there's a limitation to self-defense in libel. While a person may be legally justified in defending himself or his near relatives against libelous articles, nevertheless, he may not use offensive language against the libeler. And though a person may defend himself from charges made against him, he cannot make against his libeler a counterattack which contains libelous statements not pertinent to the matters charged in the attack. If he does, then he has exceeded his privilege and the law shall give him no protection. So that, ladies and gentlemen, concludes our discussion in media laws and ethics. I hope you learned something from this. If you have questions, feel free to contact me, send a private message to my messenger, or comment down below. Thank you very much. Amping.